Okay, great. Can everyone see the presentation and hear me?
Yes, we can hear you. Just give
Fantastic.
me 2 seconds, Lily. So I just want to welcome everyone to our training tonight. I want to thank the OAG's office for putting this on. This is an important, I think, procedural sort of a process that's going forward before the Zoning Commission. So for attendees, everyone is muted, but I believe that I have given everyone the opportunity to unmute themselves. So I think what we'll do is we will let Alexandra and Lily do the presentation, and then and thank you, Ulysses. Yes, the presentation is being recorded. So thank you for asking that. And so we will, without further ado, let them go since we've started about 15 minutes late. But what I just wanted to say was that everyone should be able to unmute themselves when they have questions. I think because both Alexandra and Lily was hoping that this would be something where we would have dialogue back and forth and questions could be asked. So without further ado, I am going to mute myself and stop my video and let them take over.
Okay. Gail, I want to say that Max is in with the attendees, so I don't know if it's possible for you to move him over to a panelist, but he was able to get on. So just quickly by way of introduction, I'm Alexandra Kane. I'm an attorney with the Equitable Land Use section. Here tonight, as Gail said, to sort of run through this recent text amendment that was proposed by the Office of Planning, 2225. And just sort of, give you an overview of what it is that is being proposed and, sort of put some questions out there for you to think about. Lily is going to be sort of taking the lead on presenting that, but that's sort of the overview of what we're going to do tonight.
Yeah, hi everyone, I'm Lily. I'm the newest member of OIG's Equitable Land Use section. So bear with me because I'm new to zoning, and so a lot of this I'm learning along with you, but I have my experts, Max and Alex, here with me, so we'll be able to answer hopefully all your questions. As Alex said, we just wanted to share with you what OP and OZ are proposing to do in this text amendment. And we hope this is a dialogue. If you have questions, we want to be able to answer them. If you have thoughts on ways that those regulations should be improved, we'd like to hear that. So please feel free to speak up, unmute yourself. So I'll dive right in. So in this 2225 text amendment, there are about 5 categories of major issues that OP and OZ are proposing to change, and we'll run through them. There's a few other smaller issues, so if you take a look at OP's set down report, they'll be in there, but we've tried to summarize the main ones here. So we'll start with notice. The first changes that they're making basically notice of any, and I just want to also clarify that this is mostly referring to the Zoning Commission, that some of these amendments are also to the Board of Zoning Appeals. But if you have questions about the difference, please speak up too. So tenants and condo boards will now be receiving notice. ANCs that will be receiving notice are current ANCs. So in the redistricting that happened in 2020 as a result of the 2020 census, if you were previously an affected ANC and then were redistricted and are no longer an affected ANC, you will no longer be receiving notice for that application. So one question we had for everyone was whether if people have issues with that, if you think that that's okay. We encourage you all to share your opinion with us, but also to share it with OZ to file comments. ANCs can file comments in advance of set down. This has not been set down yet, so you can file comments now. You can file it after set down, but always the earlier the better. And the Zoning Commission is required to consider ANC's comments. So feel free to share your opinions here, but also share them with OZ because they are the true audience. In terms of notice, August will no longer be required. I know that ANCs don't typically meet during August. The Zoning Commission does not meet during August, and so that will no longer be, if there's a 30-day requirement and someone files something on July 29th, it will not be told until the 30 days excluding August. So at the end of September would when that period would end. Set down meetings will occur no less than 35 days after the application is served on the ANC. So again, another question we had for the ANCs was whether that is sufficient time. I know that most ANCs meet once a month. If you receive notice, if somehow the timing of the 35 days and your meeting doesn't line up, if you feel that you need more notice or if that's sufficient, please share that with us with OZ, file comments. And also more broadly, ELU, our section, the equitable land use section, is just thinking about generally ways that regulations can be approved. I'm new to this, and it's been a steep learning curve understanding these regulations, understanding how they're laid out, how they play out in practice. So we're kind of thinking through how can we make it easier and more accessible. You all as on the ANC commissioners, this is not your full-time job. You shouldn't be spending so much time trying to understand the regulations. So if you have ideas about how it can be more easily understood, more accessible to non-attorneys, even foreign attorneys, it's hard to understand. Please share that with us, share it with OZ. We've been thinking about what form notice should take, if it should be mailed to surrounding residents. For example, if there's a PUD, a large project going up, what is the kind of surrounding area that should be required to get notice? Should it be posted on the site? Should it be posted within 5 miles of the site? That's maybe excessive, but we're just trying to kind of think about the scope of who should be getting notice and how. We had an idea of a QR code that if it's posted on the site, you could kind of scan it and see all the information, the most recent updated information about that application. This is just us brainstorming, throwing around ideas, but these are the types of things that we're interested in hearing. And then another issue is the OZ website. We at ELU are intervening in cases, and I find that every time I have a question about a case, I have to Google it and then go to 5 different sites on OZ's website, and then I finally get there and then I have to download something, and then I have like 12 of the same downloads because I do that every time. So kind of we were thinking about how we can make the OZ site just simplified and more accessible, whether that means case trackers, including the current status of the case. Currently, the OZ website has the current status as, I believe, active or closed, but we were thinking like, there's kind of a timeline for these cases. It gets filed and they're set down and there's a hearing, and kind of having the status of that case be more in line with that full timeline rather than just active or closed. The calendar on the OZ website, again, I feel like I have to click a few different buttons and then download different things to find out what is actually going to be discussed at certain meetings. We at ELU have been doing research, looking at other jurisdictions to see how they do it and if they have any other good ideas. And we found that some other jurisdictions have really effective calendars where everything is just in one place, where you have the square calendar grid, and then you click on a day and it shows you all the cases for that day, and you can click on a case and it shows you all the the current status of the case, and it shows you the filings and what the issues are, all in one place. So we've been thinking about that. Seattle has a weekly, I believe they have bi-weekly, but a land use bulletin, which is basically a mailing that goes out that you can subscribe to, and it will write to your inbox about all the land use decisions that's going on in that city that week or bi-weekly. And so we're just kind of brainstorming ideas how we can make this more simplified and more accessible. Please feel free to speak up now if you have questions about a specific case that are in your ANCs. Are you all able to find answers to it? And feel free to speak up now, because I know that I'm not, but I want to make sure that I'm not a dummy.
Just to sort of piggyback on what Lily said, I think the thing with all of these sort of issues that we're going to run through is that there's what's currently being proposed by the Office of Planning and the Office of Zoning, But because this is sort of a broader procedural amendment that's dealing with a lot of the sections of subtitle Y and Z, this really is an opportunity to sort of think more broadly about like what other changes the ANC or your constituents have sort of raised to you in terms of procedural issues. So we have heard from some ANCs already, some concerns about this 35-day notice period, some concerns about the fact that, the notice is sort of going to be limited to only the current ANCs. But as Lily said, this is sort of a rare opportunity to sort of think about the process writ large and, how it can be made more accessible to people, more equitable. I think we all are familiar with sort of the technological hiccups and the problems of trying to navigate the system. So that's sort of, I think, the broader thing to keep in mind tonight and sort of going forward is sort of in addition to what is currently being proposed, like what else would you like to see? What else do you think would be helpful?
Absolutely. Thank you, Alex, for that helpful background. Yeah, so again, this kind of left column is what is proposing, but we want to take that and kind of use it as an opportunity for broader changes.
So Lily, I'm sorry, I just want to interrupt. So for attendees, ANC commissioners, if you do have questions, if you want to just raise your hand and then unmute yourselves to ask those. Like I said, this is an interactive dialogue. So as Lily said, ask them, or you can always put them in the chat and we can look at that as well. Thanks. Go ahead, Lily. Thank you.
Sure, yeah. So another bucket that OZ has proposed to change is related to public participation. They have changed some of the filing deadlines. Their proposed changes are not, it's unclear how it's going to work out because they haven't actually changed the current regulations. They've made changes to an older version of the regulations, so there's just a bit of confusion that needs to be clarified there. And they're also requiring that all filings are made via ISIS or email. They're all electronic. And in terms of whether or not that is possible, we are curious whether ANCs find that easy, whether you think that's equitable and that your constituents would be able to do that, or if you have other ideas of ways that your constituents and your voices can be heard before the OZ, the zoning commission. Don't have to answer now. Oops. We're curious what time of day you file. I know this may be like a bit nuanced, but again, I know this isn't your full-time job. So if you end up filing late at night the day before, if you want a deadline that is, an hour before a hearing or a day before a hearing, kind of what you think would be easiest for you. So the OP and OZ have made some changes to the regulations concerning reconsideration. So non-parties can no longer seek reconsideration. ANCs have automatic party status, but as you may know, if you feel that you'll be affected by an application, you can seek party status, and you now have to do that if you would like to seek a reconsideration. Reconsiderations can now only be made on final orders. So for example, the granting or denial of an application, you cannot seek a reconsideration of, for example, a party status determination. So in your work with the zoning commission or the BZA in the past, have you encountered decisions that you feel were wrong and you wanted to seek reconsideration? You may not be able to do that unless it was the final decision. If that's something that concerns you, let us know, let OPOZ know.
And I mean, for the ANC standpoint for this, I think this is more sort of an issue to consider, for your constituents. The ANC is going to be an automatic party. But for constituents that are concerned about a case, unless they apply for and are granted party status, this is going to be something that is no longer available to them.
One thing that we were also thinking through was appeals. We know that appeals can be lengthy and that can delay a lot of projects, sometimes stopping them altogether. And so we've been thinking about whether a motion for reconsideration should be required before the case could be appealed to the Court of Appeals, and whether that would help the appeals process not be the one area that parties can resort to if they disagree with the decision. Okay, moving on. Map and text amendments. So OP and OZ have made a few changes to the procedures of map and text amendments. As hopefully all of you know, the comprehensive plan requires that the zoning commission do a racial equity analysis of all their zoning decisions. However, in these proposed amendments, all map and text amendments are exempt from this racial equity requirement. So we are curious why that is the case. What is special about map and text amendments that they wouldn't have a racial equity impact, and why they would be exempt. On this matter, I don't know, Alex, if you want to talk about the roundtable that's coming up.
Yeah, so just sort of as a sort of plug for another upcoming issue of concern for everybody, the Zoning Commission is holding a roundtable on sort of the substance of the racial equity analysis tool that's coming up on September 22nd. We're encouraging people to participate in that, to file comments, to attend and provide oral testimony. We think it's a very important issue. So I don't really want to get in too deep into the specifics of that, just sort of wanted to put on people's radar that that is also coming up. But as Lily said, it is currently not included for map and text amendments. It's sort of unclear whether that was sort of a deliberate choice, if that was just sort of an error in drafting, but it is currently not a requirement for those types of cases. So we wanted to put that on people's radar as something to sort of flag as a potential concern going into this.
Absolutely. Similarly, we're not sure if this is a just an oversight in drafting or if this is intentional, but there are some requirements that map and text amendments are exempt from. So there's no requirement for set-down meetings, and there's no required notice to ANCs. So that is a bit of a red flag for us. We, as Alex mentioned, are generally thinking more about the procedures for map and text amendments and how we can improve it, because they tend to be not focused on one area of a city, or because they're not necessarily one single project. It can be more difficult to garner interest in it amongst residents. It's hard for residents, DC residents, to know how they will be affected by it, if they will be affected by it. So we're trying to understand like notice requirements for a map amendment. For example, if it's a large swath of land that's being upzoned, should everyone in that zone be required to receive notice? If it's a text amendment, then it may not be, a text amendment could hypothetically affect everyone in the district, and how would we require notice in that sense? We welcome your ideas. One thing that I am certainly proposing.
I'm not sure it's gonna be ready by tonight.
Oh, sorry. I'm just going to ask the participants to mute themselves. I don't know if you can hear me, but thanks. One thing that I found helpful that OP has done kind of at a very summary level, but that we'd like to require more, is a plain language explanation or summary of text amendments. So this text amendment 2225, for example, is amending large swaths of the regulation. It's doing lots of little things here and there. And for someone who's not too familiar with the regulations, it's hard to read the regulations and understand what they're changing and what the effects will be. And so requiring OP or whoever the applicant is to provide a plain language summary of what they're actually doing and what the effects will be at the beginning of their application is something that could make text amendments much more accessible to DC residents and myself. some modifications. So these are this is in reference to modifications to applications. So if an applicant submits an application and then later their plans change and they want to make modifications to it, this is about the procedures for doing that. Currently there are sorry, correct me if I'm wrong, Alex and Max, but modifications of significance and minor modifications. Is that correct? No. Yes? Okay. Currently, you know what? It doesn't matter because it's what they're proposing to do is to do modifications with a hearing, modifications without a hearing. So that means that hypothetically, an applicant would be able to submit an application, make some change to that, and then not have a hearing on that change. So that would be fine, but at the current moment, OP has removed standards for distinguishing between these two categories, and so it's completely discretionary, and it's not clear what will require a hearing and what will not require a hearing. So we have questions about those two categories and how they'll be distinguished.
Yeah, so just to sort of clarify, so this is the modifications that were previously the minor mods, modifications of significance. I feel like there's a third category that I'm forgetting. But heretofore this would be applicants coming back to make changes to a previously approved application. So this has always sort of been a sort of fraught process as to what constitutes a modification of significance that would require a hearing versus one that could be done just sort of as a consent calendar item by the board or the commission. The ANC's always had a chance to sort of weigh in on that, but there were at least some sort of criteria as to what constituted what. So if you were, for the zoning commission, for example, if you were changing, PUD benefits, making a major sort of change to the substance of the case, that's going to be a modification of significance. But at this point, what is being proposed is sort of removed all of those criteria that would be used to sort of judge it. It's, I think, sort of vaguely stated as whether the change will affect the rights to the parties. It has to be assessed through a hearing, or whether a hearing is going to be required to assess sort of the impacts. It's not sort of clearly stated what the criteria are.
Yes, and kind of going along with that, the notice requirements for these modifications. If it's a major modification and there'll be a hearing, who should then get notice? Should ANCs get notice? Should surrounding residents get noticed? So things we're thinking through. Okay, moving on. We at ELU have also some just general concerns about, or things that we've been thinking about, or how to improve the regulations and improve the zoning process. So I've listed some of them out here and I'll run through them. But our list is, I guess, hypothetically never ending. We have many thoughts and ideas for improvements. So again, we welcome your feedback. One thing that we have been thinking through is the organization of the regulations. Being new to this, it's not always intuitive. There are sections that are labeled, this is the mixed use zone, this is the residential zone, and it has certain requirements for what can be built in those zones. And then there's other sections that refer to residential zones and refers back up in there. So it seems a little bit scattered and not everything related to one zone is in one place. In terms of the regulations relating to procedures, each section has a different notice subsection, and so you have to kind of know what section you're in before you know what kind of notice is required. We've seen some other jurisdictions do it where notice, they have one notice section and that applies to everywhere except if in your specific subsection you have an exception. So it's kind of more intuitive, everything's in one place. We've been thinking about how we can do that. We've seen some really informative graphics and charts that other jurisdictions have that help residents who are new to this, if they want to build a porch in their backyard. I'm not sure you're going to go and read all the hundreds of pages of regulations, but if you have a one-page chart, for example, that can kind of show you a flow chart of how the process works and what steps you need to go through, what forms you need to fill out and who to submit them to, and the timeline of it all. That could be something that is much more useful and helps make these regulations and the process more accessible to a wider audience. We have thought about PUD benefits a lot. The comprehensive plan makes, so I'll explain a little bit about PUDs. I'm sure that you all know this, so I'm sorry if this is repetitive, but briefly, PUDs require ANCs to negotiate, or the applicant to negotiate with ANCs to come up with some community benefits and some mitigating factors, things that they'll provide to the community in exchange for the additional flexibility and density that they're receiving, to mitigate some of the potential negative effects, and as well as in exchange for the additions that they're receiving. The comprehensive plan states that affordable housing is one of the top priorities that applicants should be giving to communities in PUDs. It also says that they should prioritize not displacing tenants in the development process. We have not seen this in practice. While the comprehensive plan does state that these should be prioritized, in effect, they're not prioritized, and the regulations do not expand on what the comprehensive plan requires. And so affordable housing and anti-displacement tools have been given the same weight as a dog park, for example. And so we've seen applicants provide many benefits in terms of the quantity of benefits that they're providing. But if it's a fence and a dog park and a lighting pole, for example, in terms of what the comprehensive plan requires, that's just as good as a few affordable housing or a few inclusionary zoning units included in the development. We are considering how to incorporate the comprehensive plan more into the regulations in this sense. We've also been thinking about mitigation requirements for map amendments, similar to how a PUD can have potential negative effects. How could a map amendment have potential negative effects, and what can an applicant do to mitigate those potential negative effects? We've been thinking through some of that. We have also been thinking about, we have 4 text amendments before the Zoning Commission right now. And these are active cases. They have not been scheduled for set down yet, but just to make sure that everyone is informed about it and knows what else we're working on, I'll mention them here. We have submitted a tenant protection and anti-displacement amendments. So these are to protect tenants who are in housing that maybe the value has gone up and they're ripe for redevelopment. Developers could potentially make a lot of money off of it, and there's an incentive to remove those tenants from the property. We want to ensure that that is not going on, because the comprehensive plan, like I said, prioritizes this. So we have case number 2205. If you're interested in learning more about that, go take a look. That addresses some of those issues. We also have case number 2215, which addresses PUD time limits. And so I believe, correct me if I'm wrong, this was ANC 4B that we worked with on this. And this was a case where a PUD was approved and then was getting delayed, and it got delayed so long that there were amendments to the zoning regulations in that time span. And by the time the PUD was going to be implemented, it was actually not up to the current zoning regulations. And so we submitted this text amendment to ensure that any updates to the regulations would have to be implemented in cases that have been delayed.
And Lily, just to pick up on that, hear me? Yeah, just to pick up on that, it's a slight bit narrower. This was a situation, a single time extension is certainly allowed. Obviously, it has to be approved by the commission for a PUD, and understandably so, because of financing issues and so forth. The concern had come up that there was, because of factors that are legitimately outside of the control of a particular developer or owner, that the project was delayed and delayed and delayed. And so the proposal was that if they were going to seek more than the time extensions that are allowed under the code, in other words, they were going to get a waiver to further extend beyond the normal limit of 1, then in that case, they should have to bring the project, the PUD, up to compliance with the current standards. We were careful to choose it to focus on inclusionary zoning and the green area ratio. So to make sure that those two sets of requirements, if they had been updated in the meantime, and the owner needed to have a time extension that more than what would normally be allowed, then in that case, they would have to bring it up to compliance with any updates.
Exactly. Thanks, Bex. Okay, next steps. So this text amendment, 2225, has been scheduled for step down on September 29th. So that's about 3 weeks from now. As I said earlier, ANCs can weigh in and submit comments before set down, and the commission must review the ANC's comments. And so there's no need for ANCs to wait. If you have thoughts and opinions, let us know. That's a typo on my end, apologies. Let us, what that is supposed to say is, let us know your thoughts and ideas. We want to know, we are representing the public interest, and we are always interested in what the public is interested in. And so let us know what you think, what you hear from your constituents. If you have questions about how to submit comments, about whether you think your comments are right, if you have questions about what OP is actually doing in this text amendment, please let us know. We're here and we're a resource. I will put our emails in the chat, but Alex, Max, if there's anything else you want to add.
Just sort of generally, again, I think another thing which I think Lily sort of mentioned at the outset is most of this amendment is focused on the zoning commission side of things. That does not mean that there are not things that can be approved on the board side. That just was not sort of where it appears that the main focus was. So that would be another just sort of, I guess, suggestion for the ANC, especially since I think the ANC is, I think a lot of your sort of bread and butter zoning interaction is on the board side. To just sort of to consider, what issues are you seeing in those cases, procedurally, what other suggestions do you have? Again, looking beyond sort of the black and white of what is being currently proposed and thinking about what other changes are needed or, might be helpful.
And I was just going to say as well, building on that, that again, please by all means contact us. We're curious. We'd like to know. We will hopefully be planning to submit some suggestions of our own. But by all means, again, the ANCs have this right that's already existing to participate. So part of what we wanted to do with this meeting was to make sure to call it to your attention so you could see and understand what's going on and participate in the process, because as the zoning commission chair himself had indicated, he's concerned to make sure that more ANCs take advantage of the opportunity to participate. And so we're trying to help get folks to do so. And again, as Alex and Lily said, to the extent we can help out, answer any questions, we're happy to do so. And we'd appreciate any thoughts and suggestions as to, if there's a more technical issue that we can try to work on to try to address if there, in other words, there's a concern that's a fairly general one and you're unsure as to where exactly would go into the code, we're happy to try to work with you to try to see if we can find where that might best fit. Thank you.
So at this time, if commissioners want to put their cameras on, if they have questions, they can unmute themselves and go ahead and ask those. Can you guys I hope you can unmute yourself. So you guys don't have to use the chat. You can actually talk if you'd like. I know people are not used to doing that, but so I think there was a question. Is there a link to this zoning case 2225? Can you explain the overall rationale for the proposed changes? Example is expected, long incoming. So maybe we can get an answer to that.
Yeah, so I'm gonna drop the link into the chat so that you have
Okay,
it.
great.
And then in terms of the rationale, Max and Alex might have a little more insight, but from what I understand, OP is just continually working on like ways to improve it. I believe their development review team, being the ones that are using the regulations regularly, submit ideas for how to improve the regulations, 1 or 2 ideas every year upwards. And then I believe this is a result of a bunch of those ideas collected and put into one regulation. It does seem like a bigger text amendment and a more in-depth changes that have been proposed, which is one reason that we are looking at it as an opportunity to address some of the deeper procedural issues that we've come across. So we encourage you to do the same. But I think OP this is just kind of a result of their routine, result of working in the regulations routinely. I don't know if you want to add anything, Alex, Max.
No, I think that covers it. I mean, this has been something that's sort of been out there in different forms for a while, and it's now being brought forward. So yeah, this is I think, a sort of a compendium of things that have come up over the years that are now trying to be addressed.
So I think I just unmuted. Deepa, if you had a question, I think you said you couldn't unmute yourself, so I went ahead and did that for you.
Okay, so just wanted to respond to the latest thing that came into the chat about providing comments before set down. So as Lily said, set down can be sort of a gray area in terms of submitting comments beforehand, unless you are an ANC, in which point there is a specific call in the regulations. It's actually subtitles the 500.9, which requires the zoning commission, in determining whether or not to set down a case, to take into consideration any feedback that they have gotten from the affected ANCs. Since this is going to apply district-wide, it is open to all ANCs to submit comments. So this really is a great opportunity for ANCs to raise, concerns that you may have, questions that you would like to see addressed, in a way that will get them before the commission, and the commission can sort of take that into consideration as they're sort of mulling over what to do with it. And, even if they decide they do want to move forward with setting it down, they can then, put those questions back on OP and OZ and request that they address them specifically in their pre-hearing filing. So it sort of really helps to make sure that, those issues are being clearly addressed. That being said, it is not the only opportunity to provide comments, especially with the ANC, since you do have your regular meetings, it can sometimes be difficult to sort of get everything lined up before a set down meeting. But there will also be the opportunity after it has been set down to file comments in the record, which again, OP and OZ will have to address as part of the overall process. Sort of as a third stage of this, because this is a rulemaking, it's sort of a legislative act. When the commission does ultimately take action, it will then enter into the formal rulemaking phase, which will require a formal 30-day at minimum notice and comment period. So at that point, the proposed text of the amendment will be sent out to all ANCs, and ANCs will again have a chance to comment on that proposed text, which will have to be addressed in the final rulemaking. So there are multiple stages to participate. But from our standpoint, trying to get comments in and sit down is a really critical stage, because it does sort of help direct what the dialogue and the conversation is going to be around the amendment going forward.
Thank
Hello?
you.
Hi. I have a comment. This is Commissioner Wilson from 8B03. Can you hear me?
Yep.
Mhm.
Hello?
Yes,
Yes.
we can hear you.
Hi. I got in a little late, and I was only able to get in by phone, so I know I've missed quite a bit. But I wanted to ask one thing: will this discussion be available for review at some other phase?
So I think Gail, you're planning on posting the video of tonight's meeting on the website, so you'll have access to it there. We have the slides that can be distributed as well. In addition, we can send around our contact information, so feel free to reach out to us, individually after tonight. We're always happy to, answer any questions or, meet with the ANC, meet with individual commissioners and sort of explain things in more depth.
And I can't access or see any of the guests or participants. So,
Well,
will that be included?
yes. So
Okay.
yes. So we're recording both audio and video. So when you'll see the link from our the anc.dc.gov page in the about ANCs. There's a training link, and that will take you to the YouTube channel, and then you'll be able to watch the whole presentation, see it and hear it.
Okay. Thank you. Thank you much.
All right. Any other questions? I went ahead and unmuted folks just so I could see if I could do it, which apparently I can. I apologize for any of you who would like to mute yourselves, which it looks like you would like to do, but I just had to see if I could do it, and I can. So that gives me great power today. But if anyone does have any other questions, you can use the raise your hand, or you can actually just ask them. But I want to make sure that everyone. So it looks like Commissioner Campbell has a question. So if you want to unmute, I can unmute you since I can do that. And I'll let you ask that question. Go ahead.
Can you hear me?
Yep.
Yes.
Okay, all right, because I thought I was unmuted before, but it seemed that nobody could hear me, and then I touched the button, and all of a sudden I was muted again. So that was really frustrating. Thank you very much for this extremely informative presentation. I was curious in terms of, because I hadn't realized that these were proposed changes. When I first saw notice of the training, I had thought that all of this stuff was imminent. So first question I have, and obviously we have the opportunity for input, but I think actually, Ms. Kane, you answered at least part of this in terms of the likelihood of these changes being made and the process by which the changes would be made. I mean, obviously, this isn't something that we need to be looking at for the start of the new fiscal year, but when and it sounded like from what you were saying that it's the Office of Zoning are the ones that need to do this, or is this amendment, does this have to go before the council?
No, so this will be going before the zoning commission because it is an amendment of the zoning regulations, which are solely the province of the commission. Council is not involved. So it'll only be with them.
Okay, so it's the zoning commission rather than the Board of Zoning Adjustment that will make these changes.
Yes.
Okay, all right. What is the earliest that you, and I realize that you're with OAG and not with zoning, but what do you think the earliest is that the zoning commission would consider making these changes? And I realize I'm asking for speculation on your part.
So it's a couple things that go into that. They'll have to make a decision on the 29th as to whether they actually want to move forward with setting it down and scheduling it for a hearing. If they feel basically, it's baked enough to move forward at that point. So that'll sort of be the first determinant. Usually after they decide to set down a case, it's based on sort of where the calendar is in terms of their caseload. It's usually, I want to say, a couple months, like we'll say 3 months maybe. We're running into the holidays, so there might be sort of additional time there, but there will be a fair amount of time in between the set down meeting and when the eventual hearing is scheduled. For the hearing, sort of, I think, dependent on what kind of public feedback they get on this, it's distinctly possible that they may have multiple hearings. That does sometimes happen. So maybe something that takes a couple evenings of testimony to sort of get through, which adds additional time. And then after that, as I said, then you sort of go into the rulemaking process. So at some point, either at the end of the last hearing or, possibly at a subsequent meeting, the commission will have to vote on the proposed language, and issue that notice of proposed rulemaking. At which point the 30-day clock for public comments on that will begin after it is published in the DC Register. So then that clock will run. They will have to decide at that point whether, based on the changes and the feedback that they're getting, whether they need to go to a second notice of proposed rulemaking, which may have that same 30-day period. It might have a slightly lesser period. So it is, I can't really give sort of a firm estimate, but it'll be a several month process. At the end of the day, I think, to get through everything and get to that final rulemaking at the end.
Okay, so it sounds, and I don't have a great deal of experience with the zoning commission, but it sounds like this is approached by them similarly to any other case that comes before that commission. Would that be a fair estimate?
Yes and no. I mean, it will go through the same hearing process insofar as there will be a public hearing. OP and OZ, as the petitioners, will sort of present their changes. There will be opportunity for public testimony. What is a little bit different is this, rulemaking stage, where there is this formal request for comment on the language that is being proposed at the end. And that may be different language than what is currently contained in the current set-down report from OP. So that is sort of where it differs from other zoning commission cases.
Okay, fair enough. Thank you very much.
Great. I think Commissioner Mehta had a question. I
Yeah.
believe she
Hi, everybody. Can you hear me okay?
can.
Great, thank you. Taking a step back from some of this, some of the procedures, et cetera, I am very interested to hear in this revamped process and with this land use section called, I think you call it the equitable land use section. What kind of, and Lily, I think you talked about the public interest and the mission of the land use section in respect of furthering and, and protecting the public interest. So my question is, what kind of role do you foresee for the equitable land use section in this process, in this process going forward? I don't mean so much the amendments, I mean the cases as, in the future. And how can ANCs access the support of the OAG when some of these things are, I mean, honestly, they're really complicated. I'm an attorney and they are complicated. I'm not an expert at all in zoning. I had a case that was quite intense for a full year. I ended up writing like a 6-page submission to the BZA, and it was many hours of work, and I would have loved some backup or some support or something like that. So is that something that the OAG foresees, as a role going forward to help ANCs in that way?
Yeah, so we have to date, just to sort of give a brief sort of background overview of what the section is doing. We've sort of been focusing on 4 major areas: affordable housing, racial equity, environmental justice and sustainability. And then the last one, which I think is the most relevant one here, is what we've sort of termed procedural equity. So that's, helping to make the process more transparent, more understandable, and more accessible to the general public, because you are 100% right. Zoning is its own very, very, very strange little world. As Lily can fully attest to as the newest member here, then trying to sort of learn and understanding is a whole job in into itself. So the way we sort of have gone about that is sort of a 3-prong approach. We have been proposing amendments to the commission to try and, do what we can to fix the regs, improve the regs, try to make changes that we think would be helpful to the district. We have also intervened in specific cases that we think raise public interest concerns, in those 4 areas. And then lastly, to your point, it's also meeting with ANCs, working with community groups, working with residents, to try and understand how the process works, to explain to them how they can participate, how they can get involved, sort of how they need to, approach a case, understand it, do the research, sort of provide as much sort of general information. Again, not always taking a position on, the specific subject matter, but just sort of providing that procedural information. This is how you get involved. This is how you sort of deal with this information. So that is something that we are committed to doing. So like I said, even after tonight, if you have questions about, this amendment and how to get involved, or just other cases or issues that are coming up in your ANC, please feel free to reach out to us. You know, it is part of our mission, but it's also sort of helpful to hear, you know, from the people on the ground, as it were, as to what issues in terms of zoning and development and land use are out there and affecting people.
I was muted. Any other questions? I don't see any other hands raised, but some folks are still unmuted if they do.
This is Commissioner Rhodes. I have a question. I'm on the phone, so I couldn't raise my hand. Can you hear me okay?
We can. Go ahead.
Cool. Earlier you mentioned about the racial equity analysis, as far as the map and text amendments that are exempt from that. Is that set in stone, or can that be changed?
So right now it can completely be changed. It is, you said, we're not sure looking at it whether it was, you know, a deliberate omission for some reason, or if it just was an error in drafting the amendment. But it's not finalized at this point. So that is 100% an issue that the ANCs can raise their concerns about and ask for clarification as to, you know, why they appear to be exempted, or to request that they be subject to that as well.
Okay, and this has to be done before September 29th?
So if you can file comments before September 29th as an ANC, that's great. That will, the commission will have to consider them. But that's not an absolute deadline. You will have other opportunities to file additional comments, or if you can't get them in by the 29th, to file, you know, your comments forthwith. But yeah, so this is, it's an important sort of milestone, but it is by no means the only one.
Okay, gotcha. Thank you.
And just to pick up on that, the benefit of participating in filing something, if one can, even in a very general sense, in other words, not specifically proposing new language, but just simply saying, for example, that in this case, as you're raising, that the racial equity you believe analysis should be required for map and text amendments. That kind of filing, if it's done now early on, it gives the commission the opportunity, if and when they decide to set it down for a public hearing, to direct the Office of Planning, the Office of Zoning to make those changes or to investigate them. And so it's really helpful to get it on the front end, so that by the time it gets to the public hearing, there's a sort of a clearer text. And otherwise it gets, the later it gets into the process, the harder it is to make changes, because the sort of the inertia, the desire to complete it and move on to the next one. So if you can get it early on, even if, or especially if it's a broader issue where I'm concerned about notice, I'm concerned about some other aspect that are raised, those are the kind of issues that are really helpful, I think, for the commission to hear at this point about what else should be included, especially because, again, you all and the ANCs are on the front lines of dealing with this. And you probably have had, you know, lots of experiences, particularly as folks who are designated to deal with it. And at the same time, it's not your day job and it's not your area of expertise. And so I think that'd be very helpful for the commission to hear from somebody who has had to deal with that, what your experiences are and how it could be made more accessible and more you know, a fairer way to participate.
Okay, thanks.
I think Commissioner Ray had a question. You can, I can unmute.
Yeah, thank you. So I, like others, remuted myself after you did that the first time. So in that vein of trying to get comments in early, because I agree with you that OP will oftentimes make a change before they get to the hearings, and it's harder after it happens. So I did point out to Jennifer Steingasser that Section 300.16, and it's a very easy line, no application shall be modified less than 30 days prior to a public hearing. And my concern with that change is that when you're dealing with a BZA case, we get noticed, you know, not that long before the hearing happens. they want to close the record effectively 30 days prior. That's not a lot of time for the ANC to meet with the applicant and maybe have changes made to the plans before we get into the hearing. So if they really make that a hard and fast rule, my concern is that the applicants will no longer want to make changes to their plans before the hearing, and then we'll be forced to try to oppose, and then go to a back and forth after, into further hearings, when we could have maybe gotten that done, in advance. So that's an area that I'm concerned about, and I've been kind of talking through it with other folks. So if that's something you could spend a little more time on too, I think that would be very helpful.
Absolutely, and I share Commissioner Ray exactly that same concern with that provision. Oftentimes, as the hearing comes close, folks tend to focus a little bit more, and all of a sudden there can be issues that are raised that can be resolved. And so I think there's a balancing act between trying to make sure that there's no surprises, which I think is the intent of having that no changes, but at the same time, to the extent there is a legitimate attempt to resolve potential issues or to provide additional mitigating, one doesn't really want to get in the way of that and unnecessarily prolong the process. So we'll definitely take a look and see what we can do about that.
Thank you.
Okay. I don't know if any other folks have any other questions. I don't see any other hands raised. So I believe that Lily put contact information in the chat. So anyone can reach out to Lily, Max, or Alex if they need to. Like I said, this will be up on our YouTube. It just takes us a day or two to get it up there, but we will get that up so folks, you can pass that on to other commissioners. I know that commissions have come back since their recess in August, so I know everyone's quite busy. But I do appreciate everyone coming on. I want to thank the OAG's Equitable Land Unit for providing us with this great training. And that's it. So on behalf of the OANC, I just want to thank everyone for attending tonight, and to have a great evening.
Thank you.
Thanks,
Yeah,
everyone.
thank you, everyone. Thank you.
All right.
Bye, Gail.
Bye. Bye, Ann. I'll see you on the 19th.
Yes.
All right. Bye-bye.
Bye.